We have different culture. We have different legal system as well. So it is our opportunity to learn about that, and then you can ask many questions for this opportunity to Prof. Munir. So before we start, Bang Dimas will read the CV of Prof. Munir.
Okay, good morning, everyone. And first of all, welcome to Prof. Muneer Abduroaf. He is a professor of Islamic law from University of Western Cape in South Africa. So, okay. Yeah, I will read his CV. He actually graduated to LLB, first in Islamic University of Madinah, and second LLB is in University of Western Cape. And then he also graduated from University of Western Cape LLM degree program, and then continued to the LLD degree in doctoral degree of Islamic Constitutional Law and Constitutional Theory in the University of Western Cape. He also working as a attorney of the High Court of South Africa, and also marriage officer of the Department of Home Affairs of South Africa, and also sworn translator of the High Court of South Africa. He speak English, African, Arabic, and German. And we have a lot of journals here. Maybe after this, you can share the Google Scholar if you want to research more about his journal and his writing. Mainly, it's about Islamic law and Islamic family law, and it will be useful for your study. And without further ado, maybe we'll continue. Give it the mic to Professor Munir Abdul Raf. Please welcome him. Please continue, sir.
Okay, shukran, Professor Jarad. Assalamu alaikum wa rahmatullahi wa barakatuh, and shukran, Dr. Yeni, for that introduction as well. My presentation today will be looking at the application of Islamic law in South Africa. Does anyone not know where South Africa is? Right, South Africa is basically in Africa. Right, it is in Africa, and the university where I am from is at the southernmost tip of Africa, right at the bottom, also referred to as the Cape of Storms, right, where it used to be very stormy weather, and it's where the two oceans meet, the Indian Ocean and the Atlantic Ocean. So the one side will find warm water, and the other side will find cold water, and that is basically where Cape Town, or the Western Cape, is situated. Right. Persons from this universe, or from this country, you know Nelson Mandela, the previous president, and there's some soccer players like Bafana, right? They come from there as well. Right. That's a bit of an overview. Let's look at Muslims in South Africa. Right. So South Africa is not an Islamic majority country. Islam in South Africa has been there over probably hundreds of years, plus minus, but not longer than that. Before that, there were no Muslims in South Africa. We can even look as to when the first person actually came to South Africa as a Muslim, as a slave, and so forth. All right, so we find that two great individuals from Indonesia, actually, here where we are currently at. Tuan Yusuf is the one individual, is the first guy or first imam that came to South Africa. He introduced Islam. And another person, actually family of mine, which is Tuan Guru, right? He came a bit later on. And when Tuan Guru basically came to South Africa, he established Islam. So when Tuan Yusuf came, there was Muslims living here, but there was no mosques. Right? Just to know also the context of South Africa. Islam, or to practice religion in South Africa, originally was forbidden. You couldn't have Jumu'ah. You couldn't really make salah in public, and these things. This was not allowed in the country. And when Tuan Guru came, the law changed a bit. They allowed churches to do certain things. And then Tuan Guru actually took the spearheaded the first Jumu'ah in South Africa. He then established the first Jumu'ah in South Africa, and basically he started the first madrasa in South Africa. And this is where Islamic law started, at least the propagation of Islamic law. All right. Now, these two individuals, based from here in Indonesia, Tuan Guru, however, he was a political exile. Right? They actually took him from here, and he had to go to South Africa, not because he wanted to, because he was exiled and he was put on a place referred to as Robben Island. Right? Robben Island, where he was actually meant to be kept quiet, so he would do things which the Indonesian government or whoever was in charge here didn't like. But when he was released, when he left the island, he actually started to propagate Islam. And this is where the first Quran in South Africa was actually written by Tuan Guru while he was on the island. Today we have many Qurans in South Africa because of but written from memory by Tuan Guru. The first Quran actually was established there. Today we have many Hufaz around the world that actually goes out in the month of Ramadan. Right. Now, because Tuan Guru came from Indonesia, we find that Islamic law applied by Tuan Guru was basically on the Shafi'i madhab. Right. So the books that he brought with him to South Africa was the Shafi'i school of law. Right. And that is what was propagated. That is what happened in the Western Cape. And only later on we found other people like Sheikh Abu Bakr Effendi coming to South Africa, but he came with the Hanafi madhab. So when Islam started in South Africa, there was only a few individuals that understood the fiqh, understood the jurisprudence, coming with the Shafi'i jurisprudence. Later on, what we found is that other scholars came and introduced different schools of jurisprudence, more specifically the Hanafi school of law. The current status in South Africa, over 150 years later, is that the Muslims living in South Africa, they primarily follow the Hanafi and the Shafi'i schools of law. All right. Now let's come in. That's a bit of a historical background. All right. I've also told you that originally you couldn't practice religion in South Africa. It was a big problem. All right. Now, subsequent to that, South Africa has also gone through something referred to as an apartheid. Right. So what's an apartheid? The apartheid was basically something where they discriminated based on the way you look and where you originate from. So if you, for example, were white of color, right, you were a European descent, you were treated in a certain way. If you, for example, were black, right, and today they say black includes Indian and Asian, right, then you were treated in a different way. For example, if there was a seat in a bus driving to from one area to another area, there's certain seats that says this is only for black people. There's other seats, these are only for white people. So the bus might be half empty or empty, and there's a certain portion of a bus that black people were in, but because the other seats were only for white people, you couldn't go. And the same applied with regard to toilets. Certain toilets were only for white people, and certain toilets were only for black people. And the same applied to beaches. You can't go to a certain beach if you're not of a certain color. So that was the situation in South Africa. And also, you had to move around with something referred to as a pass, like a passport, right, within your own country, right, to prove that you can move around. Now, the law has evolved a lot since then. we're no longer an apartheid. And we're also hearing what apartheid was happening in Palestine. And that is the argument they're using. They're saying that South Africa was changed from an apartheid to a democracy, right? Or to constitutional democracy. Now, in South Africa, as far as the law is concerned, right, and I'll come to Islamic law later on again, there's a difference between parliamentary supremacy and constitutional supremacy. Who knows the difference between the two? Parliamentary supremacy versus constitutional supremacy. What is the law in Indonesia? Is the constitution supreme or is the parliament supreme? The constitution is supreme, right? So we have constitutional supremacy. So all law or conduct in the country is subject to the constitution. Now the position in South Africa wasn't like that initially. So there were many laws that actually negatively impacted upon the citizens of the country. So even though you were born in South Africa, you never had certain rights. Now parliamentary supremacy means that the law cannot be challenged. Right? The laws cannot be challenged by a court of law. Right? The law. They are not allowed to challenge the law. Right? So that was a position in South Africa. If the law says you cannot basically go to certain beaches, the law says, look here, right, you must have, because of your skin color, you must have a certain type of a pass, a document to move around. If the law says you can't go to certain beaches, and if you, for example, were to if you, for example, were to go against those laws, then you were fined or you were locked up or put in jail. Right? So that was the law, and no one challenged it, and no one could challenge it because we had a parliamentary supremacy. The parliament made these laws, and we were bound to follow these laws. Right. However, the current state of affairs in South Africa is that we've changed to a constitutional supremacy. Right? Now, constitutional supremacy basically means that the constitution is supreme and that any law or conduct that is inconsistent with the constitution is invalid. All right, so this is now where we get into a bit of how South Africa looks at it. Section 2 of the South African Constitution of 1996. It says there, this constitution is the supreme law of the republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Right, so this is something quite different. So if Parliament basically says something, if they say, look, right, we have been chosen by the people, we are basically, they were coming? Okay, for those who came late, we're basically just looking at an overview of what the current state of affairs and a bit of historical background to the position in South Africa is. Looking at how Islamic law is applied throughout the court systems. Right. So we're looking at two things: parliamentary supremacy and constitutional supremacy. Parliamentary supremacy means the parliament is supreme. All right. So whatever laws they enact, the judiciary, who is now the courts, the magistrates court or the high court, the Supreme Court of Appeal, they have to enforce the law. That's all they can do. They can't challenge it. However, with constitutional supremacy, it means that the constitution is supreme. And the constitution says in South Africa currently, this constitution is supreme. It is supreme law of the republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. So here we find that even conduct, if we're doing something, not even a law of parliament, but if I do something, right, conduct that is inconsistent with the constitution, it is invalid. And this is important now, as we'll see later on, for Muslim marriages and divorces and inheritance and any Islamic law aspects. If those, the conduct goes against the constitution, it will be deemed to be invalid, as the obligations of this constitution must be fulfilled. This constitution also gives you a right to freedom of religion. You're no longer in the apartheid stage. It gives you the right to equality. It gives you the right not to be discriminated against. It gives you many other rights. But with these rights, you also find certain obligations. And this is something unique, basically, to a country like South Africa that gives you the right to basically have anything referred to in the Bill of Rights. In the South African Constitution, there is a Bill of Rights, and those rights are given to each and every citizen. Right? And these rights are new because prior to this, you were deemed to be in an apartheid. Okay. Now, the state of affairs in South Africa is that there's no legislation governing Islamic law per se in South Africa. So we don't have, for example, a Islamic law of marriage act of parliament. We don't have an Islamic act of divorce. And we don't have an Islamic act of inheritance. Right? There's nothing like that. Even though the South African Constitution of 1996 says that you can enact legislation governing Muslim marriages and its consequences. You have the right to do so. But, however, those provisions must be subject to the South African Constitution on the basis that any law or conduct that is contrary to the other, all the provisions of the Constitution is invalid, and the laws provided in this Constitution must be fulfilled. All right, so this is important concerning understanding the South African legal framework. So what has Parliament been doing? All right, so in this regard, since 1993, and that is basically when the South African government started to look at legislation. Right. So what happened there is that what happened there was, we all know Nelson Mandela. Right. Nelson Mandela was in jail for many years. Right. Nelson Mandela was in jail for many years, and obviously he fought against apartheid. He says, no, but we are equal. You can't discriminate between blacks and whites and all of those things. Subsequent to that, there was boycotts by the whole of the international community, stating that, look here, we can't go on like this. Let's boycott South Africa. They are discriminating against individuals. Right? It got so bad that they said, look here, right, we're stopping this apartheid, and we're going to have a first democratic elections. After the elections has come into being, we had now the coming of a democracy, which now meant that everyone had the right to vote. And they voted the African National Congress into power. What they have done subsequent to that is they have enacted a constitution that gives everyone equal rights. All right. In the constitution, it allows for legislation to be enacted. But the reality was that many Muslims, like the minister at that time, Dalla Umar, basically was married, but only in terms of Islamic law. So there was no recognition of the marriage. What happened was Nelson Mandela was asked by someone, look here, but when is our marriage going to be recognized? When will Islamic law find application? When can we actually enforce Islamic law? Nelson Mandela then asked Dalla Umar, the then Minister of Justice, Dalla, aren't your marriages recognized? Then he said that even my marriage is not recognized. There's nothing basically governing Muslim marriages. Subsequent to that, the Minister of Justice and the South African Parliament, they looked into how they're going to try to enact legislation, law that governs Muslim marriages, divorce, and referred to as Muslim personal law in South Africa. Right, so that did happen. And once there's an act of parliament, then at that point in time, we can then challenge those provisions, we can enforce those provisions in a court of law. Right, that is now the application of Islamic law in a Muslim minority country. So in 2001, they started off by drafting something referred to as an Islamic marriages bill, right, to deal with Islamic marriages. Right, they looked at countries like Indonesia, Malaysia, other places around the world, primarily Shafi'i madhab and so forth. But the reality was this issue of equality. Right? You remember, we looked at the position of apartheid, we discriminated between whites and blacks and so forth. Now we have a situation where we're giving everyone freedom to practice their religion, freedom of not to be discriminated against, but with Islamic law, we have also an issue with equality, right? What would that be? Anyone? Okay. One can have more than one wife, but can the wife not have more than one husband? Polyandry? Cannot. It's a problem, eh? So Africa allows it in certain cultures, right? There's a rain queen, and the rain queen is allowed to have more than one husband. We're actually currently sitting with a situation where we are actually considering polyandry, right? Where a husband has more than one wife. But besides that one, there's issues like talaq, right? Who issues a talaq? The husband, right? So the issue of talaq was a problem because what happens to the wife? Why can't she issue a talaq? So when the scholars in South Africa had to then make recommendations to the government to draft proposed legislation, they then came up with, for example, something referred to as tahrir talaq, where we say that at the beginning of marriage, the husband then gives the wife the right to divorce. Right? In order, within the South African context, where we have a constitution, we can't discriminate, and all of those things. So that is what has been put into that provision, for example, and also various grounds of fasq and so forth. So that happened in 2001. 2003, after public participation, they've taken that bill, they've gone right around the country, road shows and so forth, getting feedback from the Muslim community, right? They made certain changes. Initially, there was something referred to as, in the bill, referred to as a Sharia scholars, because we don't have Sharia courts. We don't have Sharia courts like here in Indonesia. They say in South Africa we don't have the capacity to deal with that. The Minister of Justice said that, look here, what do you want? We can't give you that. What else do you want? Right. We said, all right, let's make use of the civil courts. Then we said in that 2001 bill, let's have a Muslim judge presiding over all matters in terms of Islamic law based on the Muslim marriages bill, but that it can also be guided by assessors, right, by experts in Islamic law that will give him advice. Right. This was either not accepted by the government by saying, how many Islamic scholars do you have to fill all of these high courts in South Africa? So they have removed that. And then they have even then taken the position that, okay, right, it doesn't have to be a Muslim judge. Right. Can a non-Muslim judge give a ruling? Yes, no. The scholars have differed on this as well. The Alpha Tower, which is also followed by the South African ulama, because of our context, right? Okay, we'll accept. It doesn't have to be a Muslim judge, on condition that the ruling that is given must be Islamic. So therefore, there must be some type of an act of parliament that is based on Islamic law principles. But in order to fix up that, they said, okay, right, what we do need, however, are these assessors. So there will be the judge presiding over the matter, and there will be two assessors on the side, deals with and advises him how these, if the bill becomes an act, how it is to be regulated or applied to the matter at hand. All right. That was in 2001. 2003, there was another bill. 2010, there was another bill. Up to this point in time, in 2024, there's still no piece of legislation governing Muslim marriages in South Africa. All right, as to why, we don't know. Some scholars, or some of the scholars in South Africa, are saying that we cannot accept a Muslim marriages bill. And the reason for this is because it puts the Sharia under the Constitution. All right, so the previous thing there, it says, this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Which means that if there is this bill, it can be challenged against the Constitution. And if it's found to be unconstitutional, obviously changes can be made. And many scholars then stated that, or some scholars then stated, no, this is a kufr bill. This is something which we cannot accept, and all of that. And as a result, the government is thinking, look at this Muslim community, what is it that you want? We cannot go ahead. Right, that's one argument. However, with the same context, the African culture, the blacks within the country, they too have something referred to as African culture, which allows for polyandry, which allows for polygamy, and so forth, which is different to the civil marriages. However, the government has given them that. Why have they not given that to the Muslims? And that is the big question. All right. And it is normally just before elections, based on politics. We lawyers, you know politics as well. Right? Do you want this to do something in a few weeks' time? And government might be doing something. Right. But nonetheless, up to this date, there is no legislation governing Muslim marriages. Now, I will look at something which is quite unique to South Africa. Right. Muslim personal law is indirectly catered in terms of Section 15.3 of the Constitution of South Africa. Right. So here, Section 9 of the Constitution, it provides it provides for equality. Right. Section 15, it basically provides there's nothing preventing the South African government from enacting legislation that governs personal laws. It could be Christians, Muslims, whatever it might be. But here we're looking at Muslim personal law and Islamic law. So the government can do this. That is where we had the 2001 bill, 2003, 2010, and what is currently happening there. But again, it must be subject to the other provisions in the Constitution. And that is like equality clauses. Now, Section 9 of the same Constitution, it promotes equality and it prohibits unfair discrimination. Right? So what's the difference between fair discrimination and unfair discrimination? Yeah. Yeah, so the basis would be important. Why is it that you are discriminating? For example, the toilets. So there's one for the males, one for the females. We're discriminating or differentiating between But is there a logical basis? What is the reasoning behind it? Right? So until this point in time, it has been accepted. Right? Another example would be something referred to as affirmative action. Have you heard of that? So, where they said when this constitution came into being, we said we can't treat people that were privileged prior to this constitution and people who are not privileged prior to this constitution on the same level. So in the workplace, they said, look here, that people who had the opportunity to go and study, to go and work, and all of those things, but other people could not do so because of the color of their skin. We can't treat them the same. So therefore, we have to give more opportunities for those people who are disadvantaged. And that is what they refer to as fair discrimination, which is different to unfair discrimination. All right. But in this constitution, they're saying that there are certain bases of discrimination that is automatically unfair, which is including religion, marriage, sex, and gender. So you can't discriminate on these grounds. And take note of this because on this basis, Section 9, they have challenged the non-recognition of Muslim marriages within this African legal context. So then they looked at why these marriages are married into the Islamic law, you're not giving me any rights. So this is wrong. And therefore, based on Section 9, I'm challenging the non-discrimination and that you should also be allowed to, for example, inherit. You should also be allowed to do things that people within an Islamic marriage can do. And within a non-Islamic marriage can do. And this is now within this African legal context. And all of this happens in the court. Right? Again, we don't have a Sharia court, but we have a judiciary which comprises judges, non-Muslim judges, either at the bottom level of a magistrate's court or a high court, and then the Supreme Court of Appeal and the Constitutional Court. And these are the courts that South African Muslims have used in order to challenge the non-recognition of marriages. Yeah, yeah. Yeah. Hmm. Okay, thank you for the question. So, if I understand it correctly, firstly, you're asking concerning the inconsistencies within the Constitution. Does it apply to all? Oh, no. But basically, what happens within the South African Constitution is quite unique because it says that you have the right to practice your religion. But the way in which you practice it, it must be done consistent with other provisions of the Constitution. Right? For example, equality. So if you, for example, discriminate within your religion, it could be a problem. So that is when we looked at that issue of a husband can talaq and the wife cannot talaq and so forth. Inheritance 2:1 could also be a potential problem. Right? And the second part of the question is concerning it has been allowed for African culture but not for the Muslims. Right? That is a big problem. And that is what we are asking the parliamentarians. Why are you doing this for the blacks of South Africa, but you're not doing this for the Muslims? That's a political answer. And the South African government, they are actually faced with a problem, as we'll see now with these cases. Right. um, where they're challenging the the, um, the president and the cabinet for not enacting Muslim personal law. Right. So before getting there, I want to look at a few cases. Right. And this cases is the first case we look at is the case of Daniels versus Campbell. Right. Now in this case, what happened was we all understand this is the African legal framework, and this guy was married to his wife in terms of Islamic law. Right, so they had Islamic marriage, the nikah by the masjid. Right, that is how the how Islamic law applies in South Africa. The imam is there, the dawah is referred to, and a contract is entered into. Right. Now that marriage, which is now an Islamic marriage, does have a certain consequence in terms of Islamic law. You have the right to nafaqah, you have basically the talaq issues, the children born from that marriage will be legitimate, and all of that. So that is in terms of Islamic law. But within this African legal context, it was not recognized. Now, a case in point is this case of Daniels versus Campbell. This guy, or this couple, was married to each other in terms of Islamic law. The husband, however, subsequently died. Right, so the husband died. So, in terms of Islamic law, what happens when the husband dies? What is the wife entitled to? 1/8. 1/8 if there are children, if there are no children, 1/4. Right? So, these are the possibilities. But that is in terms of Islamic law. Now, in this case, they were married in terms of Islamic law, but there's no legislation governing Islamic law within this African legal context. However, there is a piece of legislation in South Africa that regulates succession, right? And that is now the Intestate Succession Act 81 of 1987. That piece of legislation, that act, then says that if you pass away and you have no will, that your wife would be entitled, or your husband, your surviving spouse, would be entitled to something. There's a calculation. We won't get into the calculation now, but she or he's entitled to something, right? By default. However, if you're married in terms of Islamic law, you're not entitled to anything because we're not recognizing your marriage. So that's a problem you're sitting with. So now in this case, Daniel versus Campbell, he then said, okay, if that be the case, I'm going to challenge this non-recognition. Because had I been married in terms of Islamic law, right, then I would have been entitled to inherit something at least. I mean, had I been married in terms of the Marriage Act, the civil law, I would have been entitled to inherit something. But because I'm married in terms of Islamic law, and there's no legislation governing Islamic law, now I'm entitled to nothing. I think that this position is discriminating against me. It's discriminating against my marriage, and therefore, now we're looking at the courts. How the South African courts, the civil courts, not the Sharia court, the civil courts, is being used by persons in a Muslim marriage in order to get recourse. Right? So here there was a surviving spouse, there was a widow. She then went to the High Court in Western Cape where I stay. And she then asked by the court papers, look here, this state of affairs is unfairly discriminating against me because I'm not entitled to anything. The government hasn't enacted legislation that governs Muslim marriages and its consequences, and therefore I'm now wanting to claim my rights. And what I'm going to say, what I'm asking for is, I want the South African High Court now to say that that Interstate Succession Act 81 of 1987 is unconstitutional. It should basically be that section that doesn't recognize me, that should be invalid. Remember section 2, right? This constitution is supreme. Any law or conduct that is inconsistent with it is invalid. Whatever this constitution says must be enforced. So this lady, she then said that using the South African Constitution, challenges existing South African law, succession or inheritance principles, and successfully um, had received a judgment stating that yes, it is unconstitutional. That piece, that section of the Act must now be read as follows. Any person married in terms of the Marriage Act, that is now the current Marriage Act in South Africa, the civil marriage, as well as any person in a Muslim monogamous marriage. So if you had one wife, one husband, you would also be entitled to inherit. And this was in a secular High Court of South Africa. However, right, there's a problem here because that, what she was entitled to, the Act at that point in time said, you're either entitled to 125,000 Rand, that's the currency of South Africa, or alternatively, you're entitled to a child's portion. And a child's portion is taking the amount of children plus a surviving spouse. Whatever that amount is, we divide that by the estate. So let's say there was R1,000,000 and there was basically uh, three children. Male or female doesn't make a difference, so African law. And the surviving spouse, that's four. So we take R1,000,000 divided by four, we're sitting with 250,000 Rand. Right? Now, 250,000 Rand is more than 125,000 Rand. The surviving spouse inherits 250,000 Rand and not 125,000 Rand. Now, that is quite interesting to note from a South African perspective, or South African law perspective. But as per Sharia, that wife is entitled to the 1/8. So the 1/8 of the estate of R1,000,000 is much less or different to 125,000 Rand or 250,000 Rand. So that is the difficulty we're sitting now with. We're a secular court, and we're looking at how Islamic law is applied. Basically, we're in Daniel versus Campbell. This matter went from the High Court confirmation to the Constitutional Court, and the Constitutional Court agreed. And therefore, all Muslims, even currently myself, is now entitled to claim inheritance if I pass away without, if my wife passes away without a will, but un-Islamic law, Islamic principles. All right. Then there was another case, the case of Hassan versus Jacobs. Now, in this case, it was different because, as we know, Islam allows for polygyny. Now, based on the principle of precedent, now precedent is basically where if a High Court or Constitutional Court hands down a decision, that decision is binding based on the set of facts. In the case of Daniels versus Campbell, it was one wife, one husband. In the case of Hassan versus Jacobs, what happened was the facts before the court was that there were two wives. This guy actually was married to the third wife, and subsequent to that, he married another wife. Then he passed away. Now, in this instance, that second wife, actually, she applied for a fasq. Now, you can see how sometimes it becomes a bit blurry as to what's happening in a South African constitutional democracy. What happens if a fasq is granted? You know, the fasq, the judicial divorce, where they go to an Islamic institution, and the Islamic institution, in this case, was the Muslim Judicial Council, SA. The wife wasn't happy with the husband, and she wanted out of the marriage. She applied for a judicial divorce by way of a fasq. The fasq was granted, and she went home. She showed the papers to her husband, and the husband took the papers and he tore it up. And then that was the end of it. And then they went on honeymoon to India. All right. Now, a fasq cannot be revoked in that way. If she has requested the fasq, they have looked into the matter, the fasq was granted. If they wanted to then reconcile, they had to remarry. And that remarriage didn't take place. But nonetheless, That was not the issue before the court. She argued, right, that she was entitled to inherit. The executor said that there was a fuss. The court looked into the matter and said, but okay, based on the state of affairs, there's an um, disagreement between the parties as to whether or not there was a marriage. But for purposes of the matter, the court take it that there were two wives. Now, this is different to the position of Daniel versus Campbell because now there are two wives in the scenario. It was in challenge that, again, that Interstate Succession Act 81 of 1987 is not constitutional because it discriminates against people in polygynous marriages. And there, again, the secular court, the High Court of South Africa, agreed with the argument made and actually gave a ruling that if a person passes away without a will, that the Interstate Succession Act 81 of 1987 also applies to persons in a polygynous Muslim marriage. Right. This last case, which is now the case of Musa versus Hanika, right, again, we go to the secular courts, where Islamic law is now again coming into question concerning the Islamic marriage. But here, this person he had a will. All right, this person had a will. And he said that when I pass away, I want my estate to devolve in terms of Islamic law. So that wasn't yet an issue. But he had two wives, which means he had a set of children by the one wife and a set of children by the other wife. When he passed away, that will was accepted by the Master of the High Court, which deals with the administration of estates. That will required an institution, more specifically again, the Muslim Judicial Council SA, to draft an Islamic distribution certificate stating who the lawful heirs are of that person when he passed away. The certificate then stated that the first wife, how much is the first wife entitled to, by the way? And the second wife? Anyone? Yes, but because there were two wives, so it will be 1/16. All right, so 1/16 to the one wife, 1/16 to the other wife. So that was not the point of contention. But the issue was if a person, in this case, again, we're looking at the secular court, we're looking at an Islamic will, and looking at Islamic principles. Now, the secular court basically was looking at this matter. What happened here was the children of the one wife then said, look here, we don't want our money. Because the document of the Muslim Judicial Council said that 1/16 to 1/16, there's children over here, there's children over there, the children inherit the residue in the proportion of 2:1. All right. The children of wife number one said, no, we're renouncing our rights in favor of our mother. The children of wife number two then said, we're renouncing our rights in favor of our mother. All right. Whether it's around in terms of Islamic law is another question because you can't really say you don't want inheritance. But you can, however, give it to your mother if you want to do so. But South African law does have a principle of renunciation in terms of the World's Act 7 of 1953. And there the act says that if a person says, I renounce my right, automatically goes to the surviving spouse. In this case, there were two surviving spouses. The spouse number one and spouse number two. Now, what's quite interesting to note here, because the court also had to look at this. The first wife was married only Islamically. All right, sorry. The second wife was married only Islamically. The first wife, however, was married Islamically as well as civilly. Two marriages. And quite interesting also, the first wife married civilly with the permission of the second wife. Right? So there was the first wife, she agreed to the marriage to the second wife, and it was Islamic marriages, and then there was a civil marriage with the first wife with the permission of the second wife. And the reason why they needed the the civil marriage, was because the banks in South Africa wouldn't recognize that Islamic marriage by the mosque. They wanted a managed by the Department of Home Affairs. So they did that, right? And when the person passed away, and this renunciation had to take place, we had to transfer the house onto the names of the two spouses, the two wives, the widows. However, the master of the High Court, all right, inshallah, I think we will continue. All right, are there any questions so far concerning the presentation? And we're giving you basically a synopsis or bird's eye view of what is happening in South Africa and how Islamic law is applied within a judicial system, basically, which is not a Sharia court. Yes. Mm. Okay. The current state of affairs, right, is that you are allowed to marry it Islamically, but as far as civil marriage is concerned, it's not possible in terms of the Marriage Act. But in terms of the recognition of customary marriages act, which is allowed for the black African community, it does allow for polygyny. So you can marry, but in terms of a different piece of legislation. The problem, however, with that is that the consequences of that piece of legislation is in terms of African customary law and not in terms of Islamic law. And that is why we need a something like a Muslim marriages bill that gives recognizes the Islamic marriage and the Islamic consequences that flow therefrom. In the absence of that, what is happening is that the South African community is making use of the Constitution of South Africa in order to challenge existing South African law principles for non-recognition. But at least what they have is they have some type of a recourse. As the opposite of that would be where they're entitled to nothing. All right. Any other questions? All right. So we're still looking at the second case was the case of Hassan versus Jacobs, and the next case is the case of Musa versus the Minister of Justice. So in this case, again, the parties were married in terms of Islamic law. They've gone to the civil legal system, right? The judiciary. And in this case, because they were married only in terms of Islamic law and not Islamic law as well as civil law, then only the one wife was entitled to that renounced benefits. And the renounced benefits that have gone to the other wife, the one married only in terms of Islamic law, it has gone to their children, the children's children. What happened there was actually one colleague, the Musa, there is Professor Musa of the University of the Western Cape. He was executor of the estate and he challenged Section 2C of the Wills Act that discriminated against the Muslim marriages. And as a consequence to that, it was then found to be again unconstitutional. Right. So in that instance, we find that the South African legal judiciary has been used to give effect to the recognition of Islamic marriages for purposes of existing South African law legislation. Right. The most recent case is what is referred to as the Women's Legal Center Trust case. What happened in this case was that the Women's Legal Center, they have taken the South African government to task. And they've said, okay, we are now living in this democracy for over 2 decades already, and still we have nothing recognizing Muslim marriage and its consequences. They also went to the High Court. Right? So again, Islamic law marriages going to a civil court and saying, look, you're right, let's ask this government why they're not doing their work. Women's Legal Center Trust then went to the Constitutional Court initially and asked them, look here, just give us a declaration stating that you have the South African government has failed in their constitutional obligation to give us what we're entitled to. The Constitutional Court then says, look here, we're the highest court of the country, you can't come to us first. You start by the High Court. Right? So a while later, they went to the High Court and they asked the High Court, please give us a declaration stating that the South African government has failed in their constitutional obligation to enact Muslim marriages, laws governing Muslim marriages and its consequences. That's now marriage, divorce, and succession. What then happened was the High Court agreed that, look here, you are required to do so. And what happened? The President of the Republic was part of that summons. He had to respond via an advocate, as well as the cabinet and many other individuals. Appeal and cross appeal, it ended up in the Constitutional Court. Again, the law in action. Muslims of a country making use of the civil judiciary, not the Sharia court, but in order to give effect to something which is dear to them, that is now the Islamic marriages. The Constitutional Court said, here, government, we are giving you 2 years, right? 2 years to enact legislation that governs Muslim marriages and its consequences. And if you don't do so, then automatically we will recognize these marriages in some other way. Right? So that is the case of Women's Legal Center Trust. Right? So the other option available with regard to succession is that either we challenge the provisions as is already enacted by Parliament, right? That's one possibility. Or alternatively, what you can do as an African Muslim is that to enforce your right to freedom of gestation, right? By stating in a will that, look here, when I pass away, I'd want my estate to evolve in terms of Islamic Sharia law, and that an institution like the Muslim Judicial Council. And this is again where we find that within the Muslim minority context, there are still institutions like a Sharia body, Muslim Judicial Council. Within the Judicial Council, even, there is a Sharia court. But a Sharia court there doesn't have enforcement powers. And therefore, you find the Muslim communities, even though they have some type of relief given there, the South African courts won't give effect to it, right? And as a result, we find that our Muslim women are going to the civil courts, because if you don't basically abide by a decision of a civil court, what then happens is that you are in contempt of court and there can be certain sanctions against you, right? So this is now the conundrum that we find within this African legal context. So basically what happens then is within succession law, you make use of freedom of gestation. The institution like the Muslim Judicial Council draft an Islamic distribution certificate stating who your lawful heirs are, and then that automatic consequences of the Daniels versus Campbell, the Musa versus Haneke, as well as Hassan versus Jacobs, those consequences won't find application, but that Islamic will then find application as far as giving effect to Islamic law. So in a final analysis, I would say that there is a need to enact legislation within the South African legal context. The judiciary does, however, give some type of relief, but that relief, however, is not in terms of Islamic law, it is in terms of existing South African law principles. There would be a need to enact Islamic law, right, like the Muslim Marriages Bill, marriage, divorce, and succession. And then as a consequence to that, that piece of legislation will be dealt with by the civil courts and also then giving effect to Islamic law consequences and not necessarily South African law consequences. And that is basically the end of my presentation. Are there any questions, inshallah? Yeah.
Since the Islamic system needs more addition, right? What's the next step after you got the permission by the government in terms of marriages, will, and testament? What is the next step for the evolution of Islamic law in South Africa? Thank you.
Okay, thank you for the question. But basically, constitutionally, there is section 15, subsection 3, which says that there's nothing that prevents the South African government from enacting legislation. All right, so what the African Muslim community has been doing is they've gone to the courts, the secular courts, and initially all they wanted to hear is, High Court judge, I want you to say, give a ruling, a declaration, they call it, that the African government is not doing their work. And when it comes to elections, you can say, look here, why should we vote for you if you're not basically going to do as what you are required to do in terms of the constitution? Right, so that is basically the leverage. And in South Africa, currently what is happening is they're changing all the marriage and divorce laws because of this constitutional court judgment, the Women's Legal Center Trust case. But in order to give effect to Islamic law, the next step would be, as we've been doing in the past, government coming back to South African Muslim communities, asking us what is it that we want to be put into the bill. But it only becomes an act once the Parliament agrees upon the contents of the bill, right? As far as constitutionality is concerned, principles, equality, and all of those things. And when the president of South Africa, the current president is President Cyril Ramaphosa, if he signs it off, Once it signs off, then it is assented to and becomes an act of parliament. And then only can our Muslims then say, "Okay, right, we are governing our marriages and also any disputes in a court of law based on those Islamic law principles." And I think that is what the majority of South Africans are looking forward to. Any other questions? Yeah. 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 So basically, there's nothing preventing them. The Constitution quite clearly states, Section 15.3, and that is what is being told by the Muslim community to the South African government. There's nothing preventing you from doing this. However, an argument is made by some that if the bill does become an act, we spoke about the 2001 bill, the 2003 bill, the 2010 bill, right? If it becomes an act, what could then happen is that act of parliament could then be challenged on constitutional grounds, on discrimination and so forth, and they're afraid of that. And and then those, it's a minority of South Africans. They're making a very big noise, right? And the government is then hearing this noise and thinking, no, but the majority of Muslims doesn't want the bill to become an act. And that is basically what some say is the reason for the delay. But that's not really a valid reason because the African community of South Africa, the blacks, have also asked for something similar, but it has been granted to them. And the bigger question is, if an act of parliament changes, let's say the act then later on says that a husband can divorce a wife, and sorry, the wife can divorce a husband by talaq, for example, without a tafwid talaq, and it says that that the son and daughter there is equal shares, for example, does that change in Sharia? There's a difference between Sharia and fiqh. Sharia is the primary sources. The fiqh would be the opinions found within the primary sources. And you find something like qanun, the legislation of fiqh. But if, for example, you were to change the qanun, you were to change those pieces of legislation, are you changing the law of Allah? Are you changing the Sharia? And this is what is being said and uttered on the radio stations in South Africa by stating that they are trying to change the Sharia, which is Allah subhanahu wa ta'ala says that Allah is going to protect it. But that is now the deliberations and discussions around this whole issue. But to answer your question, there's nothing preventing government. It seems to be as if they are afraid of losing votes. It seems to be that way. Any other questions? Yeah. Question. Yeah, as we stated from the beginning, that in South Africa, we initially were an apartheid state, which means that there was clear discrimination against certain individuals. And that was basically any person that was not white. Right? Even at university, if you were, for example, a white person and you wanted to study to be a doctor, you can't do so. But had you basically been on a different color of skin, then it would be allowed. Unless, however, correctly stated, you have special concession, you have special permission to do so. Right? And that type of discrimination had basically been applied across the board, even later on, when we see how it works, that um, our marriages were not recognized. It would have been okay had a person not married in terms of the Marriage Act and there's no recognition, that's okay. But saying that since 1993 until 2024, over a quarter century later on, still not to give them the legislation, and as a consequence to that, you are saying they should not be recognized. It basically shows why these South African, mostly women, have gone to the courts and says, "Look here, but this is not on. Uh, this constitution is supposed to liberate us, and now you're not giving us what we want, and as a consequence, we're getting nothing. Now we're challenging that as well." So I think I'm answering your question concerning what the position was, right? As far as recognition, there is still no recognition. There's only limited recognition, but in terms of South African law consequences. The Interstate Association Act is not based on Islamic law. The Section 2C of the Worlds Act is not based on Islamic law. The cases I've referred to, Musa versus Hanika, Daniel versus Campbell, and Hassan versus Jacobs. What is needed now is Islamic law consequences to be applied within the South African courts to Islamic marriages. Yes, you can. Any other questions? Hand back to Dr. Ini, inshallah.
Thank you, Prof. Muneer. Please give him a big applause for his. Thank you so much for your lecture. It is a very interesting lecture. At least we know already about how the application of Islamic law in South Africa. But I have a questions. Since in Indonesia, in such an area, it is called province of Aceh, the Islamic criminal law is applied there. How about in South Africa?
Okay, shukran for it, Dr. Eni. Now, concerning criminal law, that is something which Africa won't even touch on, right? So they're basically only looking at Muslim personal law, marriage, divorce, and succession. The criminal law is based on the common law as well as some Roman Dutch law. Yeah, so in that regard. However, even there, as I've spoken to the one colleague early on as well, has also been challenged on constitutional grounds. So, yeah, if there's any Islamic law were to come into effect, it will be challenged on constitutional grounds to see whether or not it conforms. If it doesn't conform, unfortunately, it will change. And that is the same basis which all of these women in those cases, Daniels, Musa Vasalanika, and the Hassan versus Jacobs cases, the same constitution was used in their favor. However, if something like that happens, it will also basically be challenged on the constitutional basis as well. So there's no Sharia criminal law in South Africa at the moment.
Thank you very much. Okay, please have a seat. Yeah, it's okay. Yeah, okay. Okay, students, so today, before we close our lecture today, I have announcements that for our last quiz will be held next week on Monday, starting 11 until 13. No, quiz. Our last quiz. Quiz 4. Yeah? Okay? Yeah. Yeah. Sorry? Yes, of course. As usual, but through emas dua. Yeah, don't worry. You will free. Start now for our course. Yes, AM until 1 p.m. Yeah, as our class schedule. You can do it. No, there is no class anymore. No class. Are you happy? Yes, yes. As I told you before, so I have to make it fast. I have to wrap all the course, the sessions for our course. As I told you that I have a business trip, start it this week for 2 weeks. Mau jalan-jalan dulu saya. Ani, tolong ditutup dulu. Udah selesai Ani.